Companies Act Section 176, Defects in Appointment of Directors not to invalidate actions taken. 1. Introduction. Section 176 of the Companies Act provides legal protection for actions taken by a director whose appointment is later found to be invalid due to defects, disqualification, or termination under the provisions of the Act or the company's Articles of Association. This section aims to ensure that company operations are not disrupted due to technical errors in the appointment process. 2. Purpose and objective. The purpose of this section is to maintain stability in corporate governance and decision-making. It prevents retrospective invalidation of actions performed by a director before any defect in their appointment or disqualification comes to light. The section ensures that business transactions and decisions made under such circumstances remain legally binding and enforceable. 3. Key provisions. Protection of acts done by directors. Any act performed by a person acting as a director shall be considered valid, even if it is later discovered that their appointment was invalid due to a procedural defect, non-fulfillment of eligibility criteria, or automatic termination under the Act or company articles. Defects in appointment. The section applies when a director's appointment is later found to be defective due to clerical errors, procedural irregularities, failure to meet statutory qualifications, or disqualification under relevant provisions. Termination of appointment. If a director's term has expired or they have ceased to hold office under any provision of the Companies Act or the company's articles, any actions taken by them before such termination is noticed will still remain valid. 4. Limitations and exceptions. While Section 176 grants legal protection for actions taken in good faith before the defect in appointment is identified, it does not provide a blanket validation for all actions of an invalidly appointed director. The key limitations include: no validity after notice of invalid appointment. If the company becomes aware that a director's appointment is invalid or has been terminated, any subsequent act by that director is not protected under this section. Does not override statutory provisions. The provision does not override the statutory requirements regarding director qualifications, appointment procedures, or termination conditions prescribed under the Act. Does not apply to fraudulent actions. If a director knowingly acts beyond their authority or engages in fraudulent conduct, this section does not provide immunity. 5. Practical implications for companies. To ensure compliance with this provision and avoid disruptions in governance, companies should maintain accurate and up-to-date records of director appointments, disqualifications, and terms of office. Conduct regular compliance audits to verify the validity of director appointments. Immediately rectify any defects in appointments upon discovery and take necessary remedial measures. Ensure timely filing of documents with the Registrar of Companies regarding director appointments, changes, and terminations. Adopt robust internal controls to detect and prevent errors in the appointment process. For more details, contact us.